discussing the draft report of the commission and voting on whether to submit it to the president. This draft report reflects and incorporates the comments and perspectives raised during our deliberative meeting of November 19th, as well as our previous deliberative meeting in October. As we all know, this commission was formed on April 9th, 2021 by President Biden through Executive Order 14023. Before we begin, I want to emphasize that throughout our work, we have benefited enormously from expert testimony and public comment from individuals and organizations. As the report reflects, over the summer, we held 2 days of hearings and heard from 44 witnesses. Their written testimony and that of an additional 23 experts is posted on the commission website, and we highly recommend that people read these statements. Since our inception, we have also received over 5,000 germane, unique comments from the public. And these have come from members of Congress and public officials, advocacy organizations, subject matter experts, and members of the general public. The comments were wide-ranging and addressed many of the reform proposals considered in this draft report. For instance, comments advocate expanding the size of the court or imposing term limits on Supreme Court justices. Comments also support retaining the status quo and even fixing the court at 9 justices through constitutional amendment. We are enormously grateful for the public's interest in and engagement with our work over the last 7 months. And we hope the commission's report will ultimately be a resource for people interested in the Supreme Court and its role in our system of government. Additional public comment can be submitted until December 15th via regulations.gov. And all of the comments received to date are also available for the public to view on regulations.gov. So our agenda for the day is to review this draft final report and to discuss it amongst ourselves one last time, and then to vote on whether the report meets our charge and whether to submit the report to the president. We'll begin with an overview of each of the pieces of the report. And to start that, I'll turn to my co-chair, Bob Bauer.
Thank you very much, Co-Chair Rodriguez. I'd like to begin by providing a summary, a brief synopsis of the preface to the report, which lays out the basic approach. Consistent with the executive order, the report provides an account of the contemporary public debate over the role of the Supreme Court in our constitutional system and an analysis of the leading proposals for reform of the court. Now, given the size and nature of the commission and the complexity of the issues addressed, of course, individual members of the commission might have written the report with different emphases and approaches. But the report aims to provide a fair and constructive treatment of the complex and often highly controversial issues it was charged with examining. And that is a point that the preface makes. We then proceed, following the preface, to an introduction to the report, which begins by explaining the genesis of today's reform debate, including by identifying developments, particularly in connection with recent nominations that gave rise to President Biden's decision to issue the April 2021 executive order. This introduction emphasizes that the court's composition and jurisprudence have long been subjects of public controversy and debate in our nation's civic life. Though conflict surrounding the processes by which presidents nominate and the Senate confirms justices is not new, it has become, we note, more intensively partisan in recent years. The introduction then proceeds to articulate 3 common and interrelated ideas that are frequently invoked in reform debates and throughout the report in our analysis of particular proposals in the various chapters. Those are the importance of protecting and enhancing the court's legitimacy, the role of judicial independence in our system of government, and democratic values and their relationship to the Supreme Court's decision-making. Following the preface and the introduction, we have a chapter 1, which is an extensive discussion of the history of efforts to reform the Supreme Court dating back to the founding. It highlights how lawmakers and the public have been attentive to and engaged in debate about the role that the court plays within our constitutional system. Reform debates have always involved partisan conflict and philosophical struggle over substantive constitutional values and the power of the government to serve the needs of the people. And that's discussed in this chapter. And the history as a whole is offered as context for the debate in our times. So that is how the report begins, from preface through introduction to chapter 1. And I would now like to turn for an overview of chapter 2 back to my co-chair, Commissioner Rodriguez.
So chapter 2 of the report examines proposals to expand or otherwise alter the structure of the Supreme Court. It begins with a brief history of past efforts to alter the size of the court dating back to the 19th century, and also including President Roosevelt's efforts during the New Deal era. It then considers the legality of efforts by Congress to expand the court and concludes, based on constitutional text, structure, and history, that Congress has broad authority to modify the court's size. The report then presents arguments that have been made in the public debate and are made in the public debate, both for and against proposals to expand the size of the court. The supporters of court expansion emphasize that expansion is necessary to address violations of norms that have occurred during the confirmation process in recent years, as well as to address troubling developments in the Supreme Court's jurisprudence that they regard as undermining the system of democracy. Opponents of court expansion emphasize that expansion or court packing would significantly diminish the Supreme Court's independence and legitimacy and establish a dangerous precedent that could be used by any future political force to pressure or to intimidate the court. In the report, we note that the Commission takes no position on the validity or strength of these claims. Commissioners themselves, as is noted, had opposing and strongly held views on these questions on both sides of the issue. The chapter then concludes with a consideration of other structural reforms to the court that have been proposed in reform debates, including proposals that would provide for the rotation between the courts of appeals and the Supreme Court, that would divide the Supreme Court into panels of varying sizes, and proposals that would seek to ensure ideological balance in various ways on the court itself. The report notes that some of these proposals rest on sounder constitutional ground than others, and it engages in an analysis of what constitutional issues might be implicated by these reform proposals. And then it notes that most such proposals would require significant changes to the way the federal judiciary currently functions and offer uncertain practical benefits. The report then moves from chapter 2 to chapter 3 to a consideration of non-renewable term limits for Supreme Court justices, another proposal for reform that has been articulated in public debates of long standing. Proponents of term limits argue that placing a limit on Supreme Court justices' time sitting on the Supreme Court would help ensure that the court's membership is broadly responsive over time to the outcomes of elections. It would make appointments to the court more predictable and less arbitrary. It would reduce the concentration of power in any single justice for extended periods of time and enhance the court's decision-making by ensuring regular rotation in decision makers, or more regular rotation. And all of this while maintaining judicial independence by guaranteeing long terms, often 18-year terms are proposed, and lifetime salaries for all people appointed to this position. The opponents of term limits argue that eliminating life tenure would in fact weaken the Constitution's express protection of judicial independence, which could undermine the court's legitimacy. It would further politicize the selection and confirmation process, they argue, by requiring confirmation roughly every 2 years. It would heighten the perception that justices are partisan or political actors and destabilize court doctrine. The report lays out each sets of arguments for and against term limits in extensive detail. It then, without taking a position on the merits of term limits, considers design questions that would have to be addressed were term limits to be adopted. It considers how to go about drafting a constitutional amendment to establish term limits, and then proceeds to consider whether a similar system could be adopted by statute, laying out 3 different potential statutory proposals. The implementation questions that the report broaches include: how long should justices' terms be? How many appointments should a president be able to make in each term? How would we transition from a system of life tenure to a term-limited system? And whether and what kind of constraints should be imposed on justices' post-tenure employment. The chapter also cites the challenge presented by potential impasses in the Senate's confirmation process and considers ways of addressing this issue were term limits to be adopted. For an account of chapters 4 and 5 of the report, I now turn to Commissioner Kate Andreas.
Thank you. The proposals that Commissioner Rodriguez just discussed from chapters 2 and 3 more or less accept the scope of the court's power as a given. By contrast, the proposals discussed in chapter 4 would reduce the power of the court by curbing the justice's capacity to invalidate legislation. The primary goal of such proposals is to shift power to resolve major social, political, and cultural issues to the political branches. The report examines 4 mechanisms for achieving this goal: jurisdiction stripping, supermajority voting requirements for the invalidation of congressional or other government action, rules that would require courts to show greater deference to the political branches, and proposals for a constitutional amendment to authorize Congress through legislation to override decisions of the Supreme Court and other courts. The chapter analyzes the extent to which such reforms would, in fact, reduce the power of the court or other lower courts in relation to the elected branches of government and how they could be designed. It also examines the potential benefits and costs of the proposals, and it looks at whether they would require constitutional amendment or could be achieved through legislation. The chapter ultimately concludes that the efficacy of all of these proposals depends on the details, including whether they would also affect lower court and state court decision-making. We also conclude that the reforms that would most directly reduce the Supreme Court's power over fundamental social questions are ones that, absent constitutional amendment, the court would most likely find to be unconstitutional. However, the chapter highlights arguments regarding how Congress might engage in more robust constitutional interpretation and enforcement even without constitutional amendment. Without taking a position on the ultimate merits of any of these proposals, this chapter aims to help inform further debate about whether and which reforms might be worth pursuing. Chapter 5 addresses how the Supreme Court conducts its works and explains its decisions. Although much of the public discussion about court reform has been focused on structural issues, the court's internal procedures and practices also have been a part of contemporary debates about the court's role and operations. Chapter 5 thus focuses on 3 sets of issues. The first is the court's use of emergency orders. These are orders issued without the rounds of briefing and oral argument that merits cases receive, and often also without a written explanatory opinion. Yet some of these cases involve issues of national importance or great practical impact. The chapter reviews recent controversies related to emergency orders and apparent changes in the court's approach to managing them. It notes that the court may well benefit from continuing to adjust its explanatory practices in important cases in order to provide more insight into its reasoning, to reinforce procedural consistency, and to avoid any possible appearance of arbitrariness or bias. The chapter also specifically addresses issues presented by emergency orders in capital cases, where the court often has the final word on whether a state or federal execution will go forward. The second set of issues concerns judicial ethics. The chapter reviews potential benefits and drawbacks of reforms that create a code of conduct, a disciplinary framework, or recusal review for the Supreme Court. The chapter explores the potential difficulties with these approaches and notes, however, that experience in other contexts suggests that the adoption of even an advisory code of conduct could be a positive step. The third topic is public access to the court's proceedings through the audio or video streaming of oral arguments and opinion announcements in real time. Among other things, the chapter concludes that the continuation of near simultaneous audio would enable the media and interested members of the bar and the public to better follow the work of the court. I will now turn things over to Co-Chair Bauer to discuss the remaining material in the report.
Thank you very much, Commissioner Andrius. The appendices to the report contain a variety of information we think of general interest in the debate. First of all, just for the record, the appendix, of course, reproduces in full the executive order pursuant to which the commission was established. It contains information in another appendix about our public meetings, the testimony received, and the public comments we received. Another appendix addresses the confirmation process. Throughout the report, we do note the impact and significance of the confirmation process, both in the origins of the contemporary debate and in the evaluation of particular reform proposals. It was outside our charge as a commission to evaluate proposals for Senate reform of its process to address concerns and issues that have arisen in recent years, especially in light of intensified polarization and partisanship. However, the commission did receive testimony that set out directions for reform that the Senate might consider, ones that we do not purport to analyze or endorse, but they were based on a bipartisan survey of former senators and senior staff, and we included them in the public interest as excerpts from this, in the form of excerpts from this testimony in the appendix. Another appendix addresses various testimony that we received about the sources of advocacy and information provided to the court. And it includes, just very briefly by topic heading, the diversity of the Supreme Court bar, the diversification of the appointment of amici counsel, resources for the criminal defense bar to support Supreme Court litigation, additional resources to support the court's decisions on which cases warrant review, and the court's treatment of facts included in amicus briefs. And again, this is excerpted testimony that we just provide in the public interest on topics that have arisen in the public debate and on which we receive testimony in the course of our public hearings. At this point, I would like to turn the discussion, now that we have completed the overview, back to Co-Chair Rodriguez for opening up the comment portion of our meeting.
At this point, I would invite all commissioners to turn on their cameras so that we can discuss this final report. It's good to see everybody. As with our prior meetings, there are some commissioners who've advised us that they would like to speak to the matters in the report. And so I will go through each of those individuals and then open it up for a larger discussion. We'll begin with Commissioner David Levy.
Thank you very much. I wish to thank our two co-chairs, our reporter, and the members of the commission. I thank them for their dedication and their graciousness. On the very narrow question before us, whether to approve the submission of the report to the president, I will vote yes. However, I do not support most of the proposals discussed in the report, particularly what is variously described as court packing or court expansion and term limits. I take this opportunity to put my reasons before you. My reason is that, in my view, each of these proposals, to some considerable degree, reduces judicial independence and therefore increases the likelihood that we will lose the freedom that judicial independence was and is designed to protect. Judicial independence is not for the benefit or aggrandizement of the judge or the judiciary, but for the benefit of the nation, for we the people. The rule of law depends on an independent judiciary, independent in its decision-making, which we call decisional independence, and independent as a branch of government, which we call institutional independence. It is not possible to have a successful democracy blessed with the rule of law without a fair and impartial judiciary. And it is not possible to have a fair and impartial judiciary that lacks judicial independence in both of its aspects, decisional and institutional. This is why all around the world, aspiring democracies look to our independent judiciary as the model for their own judiciaries and the rule of law. Regrettably, as the report discusses, it is also true that all around the world, autocrats attempt to achieve absolute power by destroying judicial independence and the rule of law. And they do so in part by changing the size of their highest courts and by making judicial tenure in office shorter and less secure. Through such means, the courts have been controlled by the executive. They are overpowered, awed, or influenced, as Hamilton put it so well in Federalist 78. This is why, in my view, we must approach with great caution and skepticism any proposal that has even the potential for reducing judicial independence. Because I believe that court packing or expansion and term limits pose significant threats to judicial independence and therefore the rule of law, I oppose these proposals. I hope that the president and the American people will reach the same conclusion. And I thank my fellow commissioners very much for their courtesy. Thank you.
Thank you, Commissioner Levy. Next, we'll hear from Commissioner Tom Griffith.
Thank you. I will cast my vote to approve the motion submitting the report to the president. The commission has met its charge under the executive order, which is not to say that I support the proposals discussed in the report. As the report makes clear, there was much disagreement among the commissioners about the various proposals. For example, I am opposed to expanding the size of the court, limiting the terms of the justices, and stripping the court of any of its current jurisdiction. The arguments against those proposals are set forth ably in the report. I approve the motion because the process that created the report was an extraordinary effort that deserves commendation. The commission has modeled an approach to debate over important issues that is much needed in this polarized moment. I accepted my appointment as skeptical that the views of the small handful of conservatives on the commission would be fairly considered. Yet time and again, I have found my fellow commissioners to be respectful of my views. They have gone to great lengths to see that those views are adequately reflected in the report. This is not the report I would have written had I been left to my own devices. I reject the premise of some that the current Supreme Court represents a threat to our democracy. Just the opposite. I celebrate the remarkable success the Supreme Court has achieved in preserving the rule of law, and I worry that many of the proposed changes would undermine that vital role. In a moment when some see the Supreme Court as just another partisan battlefield, we must not lose sight of the fact that the justices have played well, though not always perfectly, their part under the Constitution as impartial adjudicators. We must not sacrifice the federal judiciary to partisan impulses. My hope is that those who study this report will come to the same conclusion. Commissioner David Levy and I, both former federal judges, will elaborate on some of these ideas in a joint statement that we will be filing. Compromise for the sake of unity is the indispensable ingredient for the success of our democratic republic. The Constitution forces such compromise and assumes respectful argument and reasoned deliberation to achieve them. Historians have a name for this strand of our national DNA. They call it civic charity, and it is in dangerously short supply today. I believe that the way the commission has worked captures the essence of civic charity. In that sense, the report represents the political dynamic the Constitution demands and without which it cannot succeed. For that, I thank the president for making clear that this is the type of deliberation he expected. The co-chairs for demanding the same, and my fellow commissioners for meeting that demand. Thank you.
Thank you, Commissioner Griffith. We will hear next from Commissioner Nancy Gertner.
Thank you very much. Let me begin, as others have. I want to reiterate my thanking the commissioners, the co-chairs of this incredible effort, and I want to reiterate the importance of the commission's work. It was critical to have a discussion about the problems with the Supreme Court that we have had over the past several months in this dispassionate setting, not on Twitter, not with dueling op-eds, or worse, in a political campaign. It was critical to have this conversation with participants whose opinions are as diverse as those on this commission. Some will be disappointed that there are no recommendations to this report, that there is not a consensus document, but that was not our charge. Our charge was to outline the arguments, to talk about the pros and cons, and the report ably does that, and I will vote for it. I have a unique perspective, like Judges Griffith and Levy. I was a federal judge for 17 years. I surely appreciate the significance of judicial independence and the importance of sustaining the legitimacy of the court. I am not, however, concerned that our work comprises an implicit or explicit criticism of the court, its procedures, etc. I do not believe at all that criticizing this court risks undermining its legitimacy and independence. The reason is that far worse than criticizing the court is ignoring its real problems, to pretend that conditions have not changed when they most surely have, that efforts to improperly manipulate the membership in this court have not happened when they have, when this court has not done what its decisions have obviously reflected. Far worse than assuming that things should continue in the future as they have in the past, despite these very serious problems. In my view, that's what risks the legitimacy of the institution. Whatever short-term challenges to judicial independence come from our work are more than counterbalanced by meaningful change in an institution that sorely needs it. Advocating for change in this situation does not disrespect the courts, but undergirds its legitimacy and the rule of law. Let me say that judicial independence can never mean judicial impunity or the illusion of neutrality and the reality of something else, the appearance of fairness and the reality of partisan manipulation. In this, I'm reminded of a judge who sat in Massachusetts decades ago when an African-American lawyer raised racial bias in the jury selection long before the law made that an issue. The judge literally said to the lawyer, "Shh, don't say any of that out loud," as if making the issue clear, surfacing it somehow made the problem worse. It does not. Just the opposite. Identifying problems with the court, the ways in which it has undermined its own legitimacy, goes a long way to repairing it. My views have been reflected in this document. They have evolved from the beginning of my participation on this committee, especially with respect to court expansion. After hearing public testimony, reading the comments, hearing from fellow commissioners, watching and listening this Supreme Court over the past several years, I am more convinced than ever that change is necessary and soon, that the benefits outweigh the costs, that as is usually said, the perfect should not be the enemy of the good. This is a uniquely perilous moment that requires a unique response. One party seeks to constrict the vote, deny fair access to the ballot to people of color. The Supreme Court is enabling those efforts. That means that the usual ebb and flow of the court, changes in its composition over time as the elections change, will be stalled. The court has been effectively packed by one party and will remain packed for years to come with serious consequences to our democracy. Whatever the costs of expansion in the short term, I believe will be more than counterbalanced by the real advantages it will bring to judicial independence and to our democracy. I will vote for this report. Thank you.
Thank you, Commissioner Gertner. We'll hear next from Commissioner Larry Tribe.
Thank you. I want to thank the President for giving this commission its charge, the co-commissioners and my fellow commissioners for extraordinary work, and the staff for making it possible. The report released last night is one we can all be proud of. There has never been so comprehensive and careful a study of ways to reform the Supreme Court, the history and legality of various reforms, and the pluses and minuses of each. It turns out that some of the least controversial reforms, like term limits, would be among the most challenging to implement. And some of the most controversial, like court expansion, would be the most straightforward as a legal and constitutional matter. One sign of how fair and productive our deliberations were is that some of us started out leaning toward term limits, but against court expansion, and ended up doubtful about term limits, but in favor of expanding the court, and of some narrower ways of improving its operations as well. I count myself among that number. But in voting to submit this report to the president, I am not casting a vote of confidence in the court's basic legitimacy. I no longer have that confidence, given three things. First, the dubious ways that some justices got there. Second, what Justice Sotomayor rightly called the stench of politics hovering over this court's depressingly predictable deliberations over the most contested matters. And third, the anti-democratic, anti-egalitarian direction of this court's decisions about matters like voting rights, gerrymandering, and the corrupting effects of dark money. Those decisions are not just wrong. They put the court, and more importantly, our entire system of government and way of life, on a one-way trip from a defective but still hopeful democracy to a system in which the few corruptly govern the many, something between an autocracy and an oligarchy. And instead of serving as a guardrail against going over that cliff, our Supreme Court, I say sadly, has become its all too willing handmaiden. So with all respect, the hand-wringing over the court's legitimacy misses a larger issue, the legitimacy of what our union is becoming. To me, that spells a compelling need to signal that all is not well with the court, that it no longer deserves the nation's confidence, and that even if expanding it to combat what it has become would temporarily shake its authority, that risk is worth taking. Thank you.
Thank you, Commissioner Tribe. We will hear next from Commissioner Adam White.
Thank you. Thanks to the co-chairs and thanks to my colleagues. Like others who have spoken so far, I intend to vote in favor of submitting this report to the president. I think we've carried out our mandate, notwithstanding the fact that, as others have expressed for different reasons, I wouldn't necessarily write it the same way. And I do have profound disagreements with certain aspects or certain arguments recounted by the report on issues such as expanding the court, packing the court, or on term limits. But I'd like to speak today to a slightly broader point very briefly. I'm grateful, very grateful to President Biden for appointing me to this commission and giving me the opportunity to work with my colleagues and deliberate and study these issues of fundamental importance to constitutional self-government. In studying the arguments, I have to admit it's not always clear what premises for various arguments begin from. Oftentimes I worry that arguments about the court's legitimacy begin from a premise of expecting the court to deliver certain outcomes on demand. I think any real study of the court and reform of the court needs to begin from a very different premise, namely understanding what is the court's unique constitutional nature, its unique judicial role, and the character that flows from that nature in our constitutional system. And any reforms to the court ought to focus on what would make the court the best version of a court in terms of not just how it decides, not just what it decides, but how it goes about deciding those cases. I won't pretend that the federal judiciary is perfect, far from it. And in serving on the commission, I've come to think a little bit more about aspects of the Supreme Court and lower courts' work that might benefit from reform, such as its most discretionary actions, in which cases it takes, and also in discretionary relief that it grants to cases. But I think these are first and foremost issues of self-reform. As it happens, I think we live in an era when the most important constitutional reforms must be institutional self-reform, because the greatest threats to our constitutional system flow from a lack of self-restraint. We've seen that in the presidency, we see it in Congress, and too often we've seen it in the courts. This is a timeless issue, and I hope that any reforms try to counteract that problem and begin in self-reform and self-restraint, not making demands of the court, but asking ourselves, myself included, what the court, what our constitutional institutions in general demand of each of us. Again, I'm very grateful to President Biden and my colleagues for the opportunity to serve on this commission.
Thank you, Commissioner White. We'll hear next from Commissioner Walter Dellinger.
Thank you. I think you will see when you read the report that we did not attempt to gloss over disagreements among the commissioners. On the contrary, I think it was our belief that a healthy ventilation of these disagreements was an important part of our charge from the president, as you heard from Judge Griffin and Judge Gertner and Judge Levy and Professor Traub, all commissioners, reflecting different views that I think was a very healthy exploration of the issue. I mean, we differed, for example, on the recent history that engendered this, with some arguing that a statement that no nomination of President Obama would be considered, not just Merrick Garland, but none, effectively reduced the court to 8, only to have it raised back up to 9 when there was a more compatible president for the majority leader. Others said that this is not unprecedented in our history. We differed over how to read the Roosevelt experience. But what to me was important, and why I will cast my vote with some enthusiasm for this report, is the realization, I think, on the commission that we were not writing a report for the next 4 months or even the next 4 years. We knew not when political power would be held, when someone had the political power. Roosevelt had over 70 members of his party in the Senate. When someone would have the power to invoke these reforms and what that would mean, we know that we were writing with a longer vision than that. The testimony that surrounded Roosevelt's plan submitted to the Senate was very informative to us 40 years later, as we and our expert witnesses reviewed the debates over the Roosevelt plan. So we hope that this report's explication of the issues, done in such a civil manner and with an attempt, as Commissioner Griffith said, to make sure we explicated different viewpoints as well as they could be explicated. We hope that the report's explication of the issues might be useful a century from now.
Thank you, Commissioner Dellinger. We'll hear now from Commissioner Sherilyn Ifill.
Good afternoon. And first of all, I also want to thank not only the president, but especially the co-chairs of this commission and the staff who have supported this process and done it so gracefully. It has made this process incredibly smooth and pleasurable, and I appreciate the hard work that they've put in. I don't want to say much about the report itself because I think the report speaks for itself. As you have heard from others commenting today, it contains many of the arguments, including the disagreements and tussles among us about how to interpret history, what are the causes and effects of court practices, and so on and so forth. But what the report can't adequately reflect, I think, is some of what you've heard briefly in the comments today, but which I think we should spend some time taking stock of. When I decided to join this commission, it was not because I believed this commission was going to result in a unanimous agreement about all the issues that we undertook, and especially not as contentious an issue as whether or not there should be court expansion. But I was intrigued by the idea of a commission made up of lawyers from across various areas of practice and across the political spectrum who would come together in this exercise in a scholarly effort to present the arguments to the president and to the American people. I assumed that we would work hard, that we would push each other, that we would disagree, and that our pride alone would compel us to complete the project. I also felt that it was important for us to create the document that we've created today, that there in fact does need to be such a document that contains the information that you'll see in this report, and not just information that addresses directly the issue of court expansion or non-court expansion, but other areas of the court practice, including discretionary decision-making, transparency, recusal, and other matters that are directly related to how the court is perceived by the public. And I'm proud that the report contains these elements as well. I also thought it was important to participate because I also believe that an examination of these issues and a review of the court's practices does not reflect disrespect for the court or disrespect for the rule of law. It never occurred to me that any member of this 35-member body held such a view, but instead I took it on faith that every member of this body is deeply concerned about the rule of law, deeply concerned about the legitimacy of the courts, deeply concerned about threats to American democracy, and deeply concerned about justice in this country. And it was with that understanding that I wanted to join this commission to see if it was possible, particularly after the last 5 years, for us across the spectrum to engage in this process. I'm pleased and gratified that it was possible. It wasn't easy, but it was possible. And the document we produced is one that I feel proud of. I think it's important to pause on this moment because our profession is important to the rule of law, and it's important to the health of American democracy. What we demonstrate by our ability to come together as commissioners, to agree and to disagree, to work in a process of integrity and respect matters. It is important. And therefore, I am proud that I was a part of this process. I also believe, like Commissioner Dellinger, that this document is one that can form a platform, a scholarly platform for a continued discussion of the many issues that are addressed in the report, many of which I think are critically important. And lastly, I will just say that it is not easy at this moment in our country for a civil rights lawyer to believe that such a process as the process we engaged in is possible and can produce something positive. And so this has been a gratifying experience for me to see that it is possible, but it also demonstrates for me that it is necessary. And I hope every one of the commissioners and those who are reviewing this process will pay as much attention to what this process signifies as to the results, recommendations, and proposals in the report. Thank you.
Thank you very much, Commissioner Eiffel. I'll now open the floor to general discussion. Anyone who wishes to make a comment about the report, anything that's been said, or anything they'd like to express before we complete our work is now free to raise their hand. Commissioner Wilbode.
Thank you. I guess I wanted to, as somebody who also made a lot of critical suggestions at several of our public meetings, I wanted to chime in to say how much I appreciate all the work that's gone into getting the report to this point, and especially in attempting to, make changes and as Commissioner Griffith said, to accommodate some of the disagreements and differences in opinions we've all had. I think some parts of the report are a lot stronger as a consequence of that, and I'm grateful about them. I think some of them really are constructive additions to the conversation. I will say I fear, unfortunately, that not all of the report is successful or is as constructive in doing that. I think one consequence of where we are is that some of the most contentious parts of the report have had a harder time sometimes moving the ball forward or really coming to grips with the debates, in part, for what you've just seen and some of the fundamentally different ways some of us see these things. So I will say I've been on the fence, actually for this meeting about whether I was going to actually vote to submit this report to the president. But I am going to vote to submit this report to the president. I'm going to vote yes for two reasons. One is I keep going back to the ultimate question is whether we've met our charge. And we were charged to provide an account of the contemporary commentary and debate. We've done that. We're charged to describe historical background. We've done that. And we're charged to analyze principal arguments for and against Supreme Court reform, which we've done, including an appraisal of the merits and legality of particular reform proposals, which I think we haven't always done, but we've done the best we could given what we were working with. And I'll just say, the other reason is I do worry that voting not to submit the report would send the wrong message. I wouldn't want people to think that there's something in the report that's so, juicy or explosive that somebody on the commission couldn't live with it, or that as people have said that even this group of people have been sort of unable to figure out how to get this basic task done. So I think those are good enough reasons to vote to submit their report to the president as complete our charge. I feel compelled to add, and I hate to say it, but in doing so, I wouldn't want people to be to overpromise what people will find in their report. I think in many ways, some of the most valuable things we've received really were the process and the commentary that got us here. So I do hope when people do look back and want to study these things, that a lot of people recognize they may have to go beyond the report itself to the statements we received at our commission, to the statements we received from many, many witnesses, lots of things that we couldn't bring ourselves, couldn't include even in a 300-page report to sort of get the fuller picture. So I wouldn't want to put this front and center as the greatest contribution to the debate that people will read in 20 years, but I think we should submit it, and I think we've done our work.
Thank you, Commissioner Boat. Commissioner Andrew Crespo.
Like Commissioner Bode, I had expressed at earlier points in our deliberations some serious misgivings about earlier drafts of our report. When we met some 7 weeks ago, I indicated that I did not think at that point I would be able to vote in favor of a report resembling that initial draft, which, as I and others read it, communicated a clear position against expanding the Supreme Court. I just wanted to say how grateful I am to each member of the commission for all of the intense work that went into deliberating and substantially revising that initial draft, and to our chairs and our rapporteur for facilitating all the intensive weeks of revision that have occurred since we first deliberated. I can speak only for myself, but I wouldn't be surprised if others share the view that it would be best to live in a time when serious debate over reforming or restructuring the Supreme Court was unnecessary. Unfortunately, this is not such a time. Our very existence as a commission makes that clear. We were convened as a commission because calls to reform the Supreme Court, issued in response to deep concerns over the current court and the way in which its most recent seats have been filled, reached the very highest levels of our public discourse. As I said at our October 15th meeting, I believe the task set before us was to capture that deep, live, and consequential debate fully and fairly without shortchanging either side, including the views of the many elected leaders, constitutional scholars, and citizens who believe, perhaps regretfully, but nonetheless firmly, that the Supreme Court is indeed in need of meaningful reform. As others have said, none of us would have written the report precisely the way it's been written if it was authored as a commission of one. That's inevitable when folding the voices of dozens into one. But speaking in one voice, I believe this report presents the arguments regarding potential reforms to the court clearly, fairly, and at times powerfully. And with gratitude to everyone on the commission who worked really hard to rewrite the early drafts to make this endpoint possible, I'll be voting today to submit our report to President Biden and to share it with our fellow citizens and our legislative leaders, recognizing, as we have all the way through, that it's ultimately a decision in their hands, in the hands of Congress, to decide the path forward at this point. Thank you to our chairs and to my colleagues.
Thank you, Commissioner Crespo. Commissioner Huang.
Hi, thank you all. As commissioners, we will have ample opportunity to thank our co-chairs and our rapporteur, I hope in person before long. I think the same is true of thanking our remarkable staff, including everyone behind the scenes, including our designated federal officer team, GSA team, and everybody who we don't even see, who have been helping us with this all along. I think, though, that this is our only chance, really, to, and I hope I'm not speaking out of school, to speak on behalf of all the commissioners and thanking the members of the public who submitted comments. Thousands of you sent in comments. You thought about this along with us. You joined in this process of deliberation that we're doing today and that we've described just now, and we are enormously grateful.
Thank you, Commissioner Huang. I can wait in silence at least a minute. Well, seeing no other hands raised to make comments on the report, I think that at this moment, we'll actually take a break until the time of our vote. We have other commissioners who had a conflict up until 4:25. In order for everyone to be able to vote, we will conduct the vote at 4:25. So we'll take a break between now and then, and we will vote on the motion that we will put on the floor, and Co-Chair Bauer and I will have some remarks at that point as well. So please don't go far, and please do not forget to come back and turn your cameras on at 4:25. So we've reached the appointed hour, and it is now time for us to vote on whether to submit the report to the president on the belief that we have met our charge. So I'll begin by reminding everyone one last time what Executive Order 14023 charged this commission with doing. It charged us with producing a report for the president that addresses three sets of questions. Number one, the report should include an account of the contemporary commentary and debate about the role and operation of the Supreme Court in our constitutional system and about the functioning of the constitutional process by which the president nominates and by and with the advice and consent of the Senate appoints justices to the Supreme Court. Second, the report should consider the historical background of other periods in the nation's history when the Supreme Court's role and the nominations and advice and consent process were subject to critical assessment and prompted proposals for reform. And three, the report should provide an analysis of the principal arguments for and against particular proposals to reform the Supreme Court, including an appraisal of their merits and legality, and should be informed by a broad spectrum of ideas. The question now before each commissioner is whether we have met this charge and thus agree to submit this report to the president.
I move that we vote on that question.
Dana Fowler will call the roll and record the vote.
Commissioners, if you would please turn on your cameras. I will call each of you in alphabetical order. Please unmute when you hear your name and vote for the submission of the draft report by saying yes or yay, or against the report submission by saying nay or no. Your votes are being recorded. Michelle Adams.
Yes.
Kate Andreas.
Yes.
Jack Balkin.
Yes.
Bob Bauer.
Yes.
William Bode.
Yes.
Elise Body.
Yes.
Guy Uriel Charles.
Yes.
Andrew Manuel Crespo.
Yes.
Walter Dellinger.
Yes.
Justin Driver.
Yes.
Richard Fallon.
Yes.
Caroline Fredrickson.
Yes.
Heather Gerken.
Yes.
Nancy Gertner.
Yes.
Thomas Griffith.
Yes.
Tara Lee Grove.
Yes.
Bert Huang.
Yes.
Sherilyn Eiffel.
Yes.
Olatunde Johnson.
Yes.
Michael Kang.
Yes.
Allison LaCroix.
Yes.
Margaret Lemos.
Yes.
David Levy.
Yes.
Trevor Morrison.
Yes.
Richard Pildis.
Yes.
Michael Ramsey.
Yes.
Christina Rodriguez.
Yes.
Kermit Roosevelt.
Yes.
Virtual Ross.
Yes.
David Strauss.
Yes.
Lawrence Tribe.
Yes.
Michael Waldman.
Yes.
Adam White.
Yes.
Keith Whittington.
Yes.
Thank you, commissioners. The vote has been recorded as unanimous. Before I turn the meeting back over to the chairs, I would like to say a quick thank you. On behalf of the team here at GSA and myself, we would like to express our deepest gratitude to each of the commissioners for the hard work you've done over the last 7 months. The team and I have been honored to be along with you on this adventure, surely one of the greatest of our careers. Thank you, congratulations, and best of luck to you all. Now, for the very last time, I would like to turn the meeting back over to our co-chairs, Commissioner Bauer and Commissioner Rodriguez, for their closing remarks.
Bob, are you there?
Last technical glitch, all on me, all on me. And I have to end the way we began here with technological incompetence. I wanted to close here. Christina and I agreed I'd speak first and turn it over to her. I want to emphasize again what I think we've accomplished: 34 commissioners, widely divergent in their views on a complex and controversial topic. coming together to make a meaningful contribution to an important national debate. And all of this in 7 months. Let me just very briefly run through a few thank yous, which are more than just thank yous. They're just an acknowledgement of what it took to bring us to this point. First of all, I want to express deep appreciation to President Biden for the honor and opportunity to work on this commission with these exceptional colleagues. Truly honored. Second, I want to thank you, my colleagues. I can only express admiration, raw admiration for your commitment, deep knowledge, exceptional analytical skills, boundless collegiality, and I'm going to have to add patience, exceptional patience. Third, I want to recognize the contributions of the GSA team headed by our designated federal officer, Dana Fowler and Patrick McConnell. The phrase truly above and beyond captures what they've done here, but barely. Early morning emails, late night emails, just constant attention to the kind of detail that we need to produce a report of this length and complexity and depth. To echo Christina and Commissioner Wong, I want to acknowledge the extraordinary contribution the witnesses and commenters made. We learned so much from what they offered us, and it made the report that much better. And finally, I just have to close by saying I'm just indebted beyond measure for the opportunity to have worked with my co-chair, Cristina Rodriguez, and our rapporteur, Kate Andreas. I can't describe to you the effort they brought to the work and the skill, the thoroughness, the deep learning, and always good humor they brought to it. I'm just extraordinarily fortunate to have gotten to work with them over the last 7 months. And I want to stress again, what the commission did was to demonstrate that something is possible in this very polarized time that some people don't imagine is, but it's urgent and necessary work. And this commission has demonstrated that it can be done. So thank you from the bottom of my heart. And now I'll turn it over to my co-chair, Cristina Rodriguez.
Thank you, Co-Chair Bauer. It's been an honor to be on this adventure, as Dana put it, with you and Kate, who I count as now intellectual inspirations and friends. I want to thank the president for appointing me to this commission. It was an extraordinary honor at the time, but I don't think I understood the half of what it would entail. And I want to thank him for assembling this fine collection of people. The work we were asked to do was a challenge of the very best kind. As Bob said, I and we are deeply grateful for the work of Dana Fowler and the staff at GSA. We could not have met our charge and had a unanimous vote of yes and a report of the quality that we did without them. It would not have been possible. I'm also extraordinarily grateful for all of the commissioners' willingness to have very difficult and sometimes unpleasant conversations, but to do so face-to-face over Zoom with good humor and above all, seriousness of purpose. And to everyone's commitment to making sure that we produced a report that was constructive and fair and that everyone could feel good about. It's noted in the report, and commissioners have emphasized this throughout our time together, that no single person would have written the analysis in the way that the report ultimately presents it. But I also think it's important to acknowledge that no single individual would have been able to produce the monumental report that we now submit. And for that, I am proud and look forward to seeing you all again soon. Bob, you're muted. I don't know what you're saying, but I'm sure that
it was profound. It was profound, but it's now lost to the mists of history. Lost to the mists of history. If there's no further business, I think, before this commission, then I think that we should adjourn. So barring any further comments or questions, we are adjourned. Dana Fowler, is there anything else we need to do to bring to a conclusion of the proceedings?
No, sir.
Have a good evening, everyone.